Hey there, and welcome. So, you have a court-ordered parenting plan, but does your co-parent treat it more like a rough suggestion? If that sounds familiar, you're in the right place. We're going to break down how you, yes you, on your own, can enforce that plan and bring some much-needed order back to your life and, most importantly, your child's life. Let's get started on that path from chaos to control.
Right? This is the question. It's the one that keeps so many parents staring at the ceiling at night. You've got this official, legal document, but weekend after weekend, it gets ignored. You're left feeling frustrated, totally helpless, and probably worried sick about your kid. But the good news is, there is a now what. You have options. You actually have a lot more power than you think.
And this, right here, is the most important thing you need to burn into your memory. A parenting plan is not a friendly agreement. It is a legally binding court order, period. So when a parent violates it, they aren't just being difficult. They are, in fact, violating a direct order from a judge. Our goal today is to give you a clear, step-by-step guide to take you from that chaos of constant violations to the control of real enforcement.
Okay, first things first. To solve a problem, you have to be able to name it. Because let's be real, just telling a judge they're not cooperating isn't going to cut it. You need specifics. So we're going to look at 4 very common violations so you can clearly identify and document exactly what's happening.
This is the big one, the most direct violation there is. It's when you show up for your scheduled weekend and the other parent just says, no. It also includes all those last-minute cancellations that come with flimsy excuses, or when they just don't bring your child back on time. It is a direct interference with your child's fundamental right to have a relationship with you.
This excuse is so incredibly common. You've probably heard some version of it yourself. But here's the deal. Unless there is a real documented safety concern, a child's preference doesn't override a court order, especially when that preference is being, let's say, influenced by the other parent. A text message like this, that's not just an excuse, that's Exhibit A of a violation.
Okay, this one is serious, like really serious. In many states, like Missouri, for example, a parent is legally required to give 60 days written notice before they move a child's main home. And listen, this isn't just about moving to another state. It can be a big move across town if it messes up the whole custody plan. Trying to do it secretly is a massive violation of the court order.
You know where this quote comes from? It's often written right there, plain as day, in the parenting plan itself. It's a built-in warning label. It means the rules for moving aren't some hidden legal secret. They're part of the order you already have. Go ahead, pull out your plan. I bet you'll find something that sounds an awful lot like this. You know, violations aren't always about missed weekends. Sometimes it's about creating a toxic, stressful environment that's just plain bad for your kid. If every single pickup and drop-off is filled with yelling, insults, or tense arguments about adult stuff, well, that can violate the part of your plan that requires parents to be respectful and, not create a war zone in front of the children.
Just picture that for a second. Imagine the damage that does to a child who has to hear that. It completely undermines their security and their relationship with the other parent. This isn't just bad co-parenting. This is a clear violation of the entire spirit and often the actual text of the court order.
Now, this one can be a little more subtle, kind of sneaky, but it is incredibly damaging. If you have joint legal custody, that means you're supposed to make the big decisions, health, education, all that together. A violation is when one parent just decides to change the child's school, or starts them on a new medication without even talking to you, or, a classic one, blocks your number on your child's phone. And this is a perfect and frankly chilling example of that. This isn't an accident. It's a calculated move to systematically cut a parent out of their child's life. It doesn't just violate the parenting plan, which guarantees you access to those records. It can also violate state law. This is about more than just missing a newsletter. It's an attempt to erase your role as a parent.
Okay, so you've put a name to the violation. Now what? How do you actually prove it? This, my friends, is where you stop being a victim of the situation and you start taking control of it. Documentation isn't just busy work. It is the evidence. It is the raw power that transforms your case from a messy he said, she said argument into a factual, undeniable record a judge can act on.
Here's your action plan, your game plan. Number 1, start a journal. Today, log dates, times, and just the objective facts of every single incident. 2, save everything. Screenshot every text, save every email. 3, get records from other people. If police get involved, get that report number. And 4, use photos and recordings, but only where it's legal. In a one-party consent state, for instance, an audio recording of a hostile exchange can be unbelievably powerful.
Because here's the bottom line. Your credibility is everything. When you walk into court and present a judge with a calm, organized, fact-based log of events, you become the reliable narrator of the story. You have to resist the urge to add emotional language or exaggeration in your journal. Just the facts. He was 25 minutes late. Not, he was late again because he doesn't care. This is how you build trust. This is what makes your case so compelling.
All right, you've got your proof organized. Now what do you do with it? Well, it's time to open up your legal toolkit. The court system gives you specific tools to handle these problems, and you don't have to be a lawyer to understand them. You just need to know which tool is the right one for the job.
So these are your two heavy hitters. Think of it like this. A family access motion is your specialized fast-track tool. It's designed specifically to deal with denied visitation, and it's quick. Its goal is to get you remedies, like make up parenting time and maybe even attorney's fees. A motion for contempt, on the other hand, that's the big hammer. It's for any willful violation of the court order, and its purpose is to punish the other person for disrespecting the court. We're talking more severe sanctions here, like big fines or even jail time.
And you've got a couple of other specialized tools in the kit too. A motion to modify isn't really about punishing what happened in the past. It's about changing the plan for the future, because it's pretty clear the current one just isn't working anymore. And police involvement? That's for right now, for immediate safety concerns, or when a clear crime, like custody interference, is happening right in front of you.
Okay, we've identified the violations, we've gathered the proof, and we've looked at our legal tools. Now let's put it all together and see it in action. This final section is going to walk you through a real-world scenario to show you exactly how this process takes you from the moment of violation all the way to a court-ordered resolution.
Check this out. This is how it works. Friday night at 6 o'clock, you get the text. The violation happens. You document it immediately by saving that text, and then you call the non-emergency line to file a police report. First thing Monday morning, you're at the courthouse filing your family access motion. Within a few weeks, you are in front of a judge who not only orders that you get your parenting time back, but also slaps the other parent with a financial penalty.
And that's it. That is the journey. You took a frustrating, messy, chaotic situation, and by following a clear, logical process, you turned it into a concrete, enforceable solution from a judge. This is what taking back control looks like. You didn't yell, you didn't argue, you didn't escalate. You just used the system exactly how it was designed to be used.
Now, this number is important. In a family access motion, in a state like Missouri, a judge can order the parent who violated the plan to pay a fine of up to $500. Not to the court, but directly to you. This is proof that there are real, tangible consequences for ignoring a court order. It's not just a slap on the wrist. It can actually hit them where it hurts, their wallet.
So I'll leave you with this question, a call to action. What is one small, factual thing you can write down today, right now? Maybe it's that the exchange was 15 minutes late. Maybe it's saving that weird text message. Or maybe it's just opening a new notebook and writing today's date on the first page. That first entry, that's your first step. Your first step from chaos to control. Your child's right to have a strong relationship with you is absolutely worth protecting, and it starts right now.